as I can see, it is being streamed live on Facebook.
In bottom also we are started connecting.
Okay.
Now it's crossing 60, the numbers, it's increasing.
It is showing now 66.
We've almost reached the maximum number of participants, sir. So the remaining participants will be redirected to their Facebook pages, where the Zoom meeting will also be shared live, so they can watch it there as well. So
94 it is now.
Yes. I would like to request Mr. Ellen to start with the inaugural.
May I welcome Professor Ranjit to. Professor Ranjit, you are most welcome to the webinar to deliver this lecture. And I, on behalf of IITArb, welcome you to this lecture. Kindly start your presentation. Thank you.
Thank you, Mr. President. Today we are going with a another interesting topic about the contracts. And when it comes to contracts, the very popular person in our Chennai city is Dr. Ranjit Ommen Abraham. We are quite happy to introduce him. He is an assistant professor for contracts as well as torts in the School of Excellence in Law, Tamil Nadu Dr. Ambedkar Law University. He has a master's in business law. That also he completed in the same institution, and he was initial professors who took up that assignment in that institution, which is considered to be one of the national law schools in state of Tamil Nadu. Further to that, he completed his doctorate in IPR, intellectual property rights, and now he is very sort of professor teaching the contracts, particularly the contract principles, and here he is going to share with us the contract enforceability issues. We welcome on behalf of KFCRI and IITArb, we welcome Dr. Ranjit Abraham.
Thank you. Can I start?
Yes, sir.
I'll just share the screen now. Okay. I hope you can see the PPT on the screen. So, firstly, can you all hear me?
So, just a minute, sir. Before we start, I think they would like to establish the housekeeping rules so that our participants will be familiar with the Zoom app as well. Sorry for the interruption.
Carry on, no problem.
Yeah, sorry for the interruption. Thank you, Mr. Swethan, and thank you for all the respected engineers gathered here for giving me this opportunity. Before I give a brief on bit of housekeeping rules which should be followed on this virtual session, let me tell you what is KFCRI and IITArb association is all about. KFCRI, Kovise Foundation Conflict Resolution International, is one of the fast-growing institutions globally. So, in its function, it has its own two diversified roles. One is an institutional role, another one is an accreditation role. So, if you take us an institution, we represent as a KFCRI institution. We do take arbitration cases. We assist certain engineers in taking up this arbitration cases. For example, in this good crisis time, we can actually make use of virtual space for conducting an arbitration. So KFCRI is doing such prominent roles in helping out so many engineers in doing the arbitration cases. So if you take the primary objectives of KFCRI, we promote arbitration and other area practices, and we do have our own rules like arbitration rules, mediation rules to monitor all those proceedings. Similarly, if you take as an accreditation body of KFCRI, we accredit so many members. We accredit as associate, fellow, and affiliate. So we do have a hierarchy of our members. So similarly, if you take IITArb, I guess all of our engineers are very well aware. We KFCRI and IITArb actually share common minds. So it's a two different body. We have a common minds. That's why we became closely associated, and we function as a close association. And we do as a close association, we are doing so many webinar sessions. so many trainings, so many workshops together. And one such session is this virtual session we have gathered here in the topic of contract enforceability issues. So a bit of housekeeping rules, like to have a small favor among us is that I would request to all the engineers to just to please avoid using the chat box. Whatever the questions you have in your mind, just please put it in the Q&A box so that it will be asked in the last 15 minutes. And if you have any other glitches, technical glitches, or if you can't hear us, or for any other problems, you can just put to us in the chat box. And that's a bit of housekeeping rules. And to know more about our institutions, I'll just put in the chat box our institution website. You can have a visit in your small free time. So I'll just hand over to Mr. Ranjit sir to all of the session. Thank you, sir.
Thank you. So before I could start my lecture on this webinar, I'd like to thank both KFCRI and IITArb for inviting me for this webinar. A wonderful opportunity for me to talk to many eminent panelists who are hearing me, and also the audience who are listening. I love to do that because it's something different than what I regularly do, talking to students, young students, which is even more dynamic in nature. But at the same time, talking to experienced people is a process where we also acquire a lot of knowledge which we disseminate to our student fraternity when we future give further lectures. So I thank both the organizations for having invited me. And I've been talking in arbitration training programs, thanks to the invitations given by both the organizations sometime before also, on general principles of contract and all. And I know that this is a second webinar after Anirudh gave a webinar last week, which I happened to listen through the YouTube, which was on frustration and force majeure. So I have given my, I'm planning to give my lecture in a manner in which I don't try to overlap much in what a wonderful lecture which Anirudh has given. So my lecture would be on contract enforceability issues. Obviously, I'll also deal a little bit on frustration, force majeure, vis majeure, and also on those aspects. At the same time, I'd like to talk about more other issues, other prominent issues, which arise out of a general contract and also in particular to a construction contract. So basically, we all know what is a contract on an introductory aspect. So a contract is a agreement enforceable by law. This is a simplest definition which has been given in any contract book or for any contract lawyer for that case. But at the same time, when we are talking about a contract, because we all live in a world of agreement, but when we talk about a contract, what is the most important aspect of it to differentiate it from that of an agreement is enforceability. So if an agreement is not enforceable, then it is not contract. So enforceability issues in contract is one of the most important topic, not only for a academic lawyer, but also for a practitioner lawyer, and also for the whole world at large. Because what is the importance of contract? You need contract for day-to-day living. Today we are living, even in the times of pandemic and epidemic, we live by entering into many contracts. There may be restraints and constraints in entering into a contract in the present scenario, but we can't be devoid, or we cannot avoid entering into a contract. So that is obviously a daily requirement for living at whatever condition, even at times of war. So we are dependent on contractual obligation. So for getting all our needs, including our basic needs also. So we need a very good commerce and trade to prosper in our country for our own development, and for which we surely need a good contractual legislation and also a contract law. The economy of the country also has a lot of integration and dependence on contracts. So for which we need better reliability of people who are to make sure that the obligations are made clearly, and also they need consistency in the promises what they make, for which contract law is one of the most important laws in our country. So basically, I know many of you might know this, but at the same time, when you analyze and understand it, there are essentials of a valid contract. In short form, I say this is the formation of the contract. So when you look at the formation of the contract, you need certain criteria which is given under Section 10 of the Indian Contract Act. So offer, there should be a valid offer, there should be a valid acceptance, there should be parties who intend to create a legal relationship. Capacity of the parties should be as per the law given in our country. The consent of the parties should be free and it should not be affected because of any conditions which should not be there according to the contract law. The objects should be lawful, and of course there are other reasons given, like the certainty of the contract should be there. There should be possibility of performance, and the agreement should not be expressly void. These are the list which is given under Section 10. I tell my students for understanding, whenever there is an agreement which is coming to your side when you become an advocate, when you are a lawyer, when you are a practicing lawyer, your judicial mind or legal mind should invoke this OACQ Bell formula. It is a small formula where offer, acceptance, 3 C's, consent, capacity, and also consideration, all should be according to law, and of course the legality of an object. In addition to that, we all might know about this famous case of Balfour versus Balfour, where we started this intention to create legal relationship. So it should not be an unintended non-contractual relationship which need to exist, but it needs to be a contractual relationship which had that intention to enter into that kind of an obligation. Many people confuse over this intention to create legal relationship, but it is simply a fact where when two parties are entering into the contract, at the time of entering into the contract itself, they should have the intention to perform the promise. And if the other party does not perform, they should have the intention to enforce the contract by appropriate law in which they are, in which jurisdiction they are serving. That intention is also very, very required. Writing and registration are required only if it is going to be contracts made by certain specific laws where writing is mandatory, like transfer of property, etc. Otherwise, it's option which is being given, right? So we all enter into a lot of contracts. So we need, when you look at the Indian Contract Act, the first part talks about valid offer and valid acceptance. There are a lot of conditions, like communication offer should be there. There are conditions like offer should be clear, offer should be certain, offer should be made by the offerer to the offeree. So there is a list which is given. Same ways for the acceptor also. Acceptance should be communicable. Acceptance should be clear. Acceptance should not be silent. And these conditions has to be followed for a valid offer and acceptance. Our Indian law and also English law talks about revocation of offer and acceptance, and they prescribe certain conditions. In India, we popularly call it as postal rule of revocation, whereas in English law, also we call it postal rule of revocation. But in today's scenario, in the internet world of communication, the world of e-commerce, it's popularly called as mailbox rule of revocation of offer and acceptance, because we are sending a lot of offers and acceptance to internet through email and all that. So obviously today everyone should know about the rules which are pertaining from the mailbox rule. That is, whether offer can be revoked if it is an email sent offer, whether acceptance can be revoked when it is an email sent acceptance. And of course, Information Technology Act has also been, the legislators was good enough to have few sections where they have enacted certain rules and regulations where it is possible legally, but technologically it is not possible because of the speed of the internet, where the revocation becomes very difficult. So these are the important aspects with regard to offer and acceptance. So as I told you, always the parties should intend to enter into a legal relationship where their understanding and the seriousness of contract law matters a lot. Because many people imagine they have entered into a world of contract, but as per the law, they might not have entered into a world of contract. Even in construction contract, I've read many articles which gives the fact that people live in a world of imaginary world of entering into a contract. I'll justify what I'm telling now, not now, but after a few more slides. So this is a very, very important aspect. And consideration. Section 2, Clause D of the Indian Contract Act defines consideration. it talks about various criteria which is there for a valid consideration. But at the same time, we also should understand that consideration is nothing but something in return. And Indian Contract Act has many laws which says that consideration need not be adequate. Section 2D testifies that consideration can be past, present, or future. And in every contract, if consideration is not there, then the contract is not there. Section 25 gives you a lot of exceptions when consideration need not be there under certain very rare circumstances where it is made out of natural love and affection, or if it is given as a gift, etc. You can come out of consideration. Otherwise, if consideration is not there, then the contract becomes void. Capacity of parties. So parties entering into the contract should be of sound mind and should be having the age of majority and should not be disqualified. These are some of the important issues. And when they are not sound mind, many people ask a lot of questions about lunatic period of lunacy, and also when people are involved in alcoholic addictions, at the time they enter into a contract, that contract may not be legally valid if proved at the time of entering into the contract either one of the contracting parties was not of full sense. They were not able to think rationally. They decide properly whether they can enter into a contract or not. When it comes to minors contract also, our law is very clear. Minors contract is void ab initio. That means void from the very beginning of very starting stage itself. So that is where we discuss about the importance of making sure the person to whom you are entering into a contract is not a minor. Consent of the parties should be free. That means in all agreement there is consent, but only if the consent is free, it will become a contract. That means the consent can be forced consent. And our Contract Act gives 5 conditions like coercion, undue influence, fraud, misrepresentation, and mistake. Under these 5 conditions are there, the contract will not be valid. It will become a voidable contract according to Section 19 of the Indian Contract Act. And so we all know voidable, meaning of voidable. Voidable at the option of the affected party. So this is where we discuss. So coercion is nothing but a fact where someone is threatening you to enter into a contract by coercing you. Undue influence is a fact where there are people who are entering into a contract are not at the same level. People who are entering into the contract are of one party is dominating the will of the other party. Section 16 of the Contract Act deals with that. Fraud means Section 17 deals with that, where we say that the one party is cheating in another party or willfully, intentionally frauding the other party to get the consent of the other party by telling a fact wrongly with the intention, with the knowledge that it is wrong and with the intention to deceive the other party. Misrepresentation is unintentional fraud, where the one party is telling something wrongly without knowing it is wrong. And mistake is where parties are making a mistake. Either it can be unilateral mistake or it can be a bilateral mistake, and accordingly they are entering into a contract. So today, when we enter into a contract also, it should be lawful objects, like it should not be fraudulent, it should not be illegal, it should not be immoral, or it should not be opposed to public policy. Many contract law students in the beginning, they think that talking about public policy is irrelevant. But there are a lot of Supreme Court cases where the court have decided contracts to be void on account of public policy and also account of immorality. Though the statute has not given a clear-cut definition, what is immoral, what is moral, what is public policy, courts are taking that into consideration then and there according to each and every circumstances of each and every case. This is what is being discussed about lawful objects, which are very, very important. So this is why we say that you need a lawyer's mind at times when you think about contract. You should not only think about Indian Contract Act, you should think about all the laws. You should also know about the public policy. Then only you can decide whether a contract is valid or not. If you only think about Indian Contract Act, then you will not be fulfilling Section 23, Section 24 of the Contract Act, which are also an important requirement for making sure a contract is legally valid. And section 25 to 30 deals with a lot of sections which deals where statute itself has made certain agreements to be void, like agreements against marriage, agreement in restraint of legal proceeding, agreement in restraint of trade, ambiguous agreement, wagering agreement. Like that, they have a list of agreement which the statute itself has directly made it a void agreement. Why this is very important is tomorrow when you are drafting an agreement, even an element of wager is there, then or ambiguity is there in the agreement what you are drafting. Double meaning is possible. Both the parties have different interpretation of what is the contractual obligation. Then obviously that contract becomes void because of the statutory voidness which has been created within the statute itself. So you have to be very careful with regard to this also. So what are the important stages in the formation of, in the general principles of contract? First, till now what I discussed to you talks about formation of a contract. When everything is there in accordance with law, then we say a contract is formed. Just because of contract is formed, we cannot complete the study of contract because of the fact that this is only the preliminary stage of a contract between two parties. Subsequent to that, they need to have the post formation of contract period where parties have to perform the contract. If they perform the contract according to the obligations which they have promised, according to the contractual terms and conditions, there ends everything and there is no room for dispute. A contract becomes a good contract and parties are happy to each other. But the dispute starts when the parties don't perform according to what they have promised. So when that is the time when they are committing a breach. They are committing a breach when they are not performing the contract. So when they commit a breach, it can lead to dispute because the parties are not happy. One of the parties is not happy or both the parties are not happy. It leads to breach. And when it leads to breach, it leads to dispute. When it leads to dispute, we have to understand what remedies are there in law. And if the remedy comes in the form of dispute resolution. And I'm sure that many audience who are listening today are living in the world of, not only in the world of formation of contract, that is maybe your all expertise in construction contract, but also in the world of resolving dispute between the parties in the form of arbitration, which is one of the most important form of dispute resolution, which the whole world is now talking about. So you understand it in that particular way. So you want to get discharge of the contract when it is not by performance, you have to get discharged by breach. You have to get discharged by agreement, where both the parties say, okay, you are not performing, let us get discharged under these conditions. A, B, C, you put the conditions and you get discharged. Or sometimes, like what Mr. Anirudhan spoke in the last webinar, you get discharged by impossibility of performance, by way of frustration, by way of impossibility of an act like force majeure clause, which has happened either through act of God or through an act of state intervention or through act of legislation or act of a change scenario, which is not possible to render the contract practically to happen in a proper way. So these are the various criteria in which we get discharged from a contractual obligation. Always I tell many people wherever I speak, when two parties enter into a contract and when they are in the world of obligation, it is very good to get obligation from the other party. When you will have to perform, it is where your problem starts. And the most important word which comes to your mind is discharge. When am I going to get discharged? So you feel that you have completed your work. Like today, when I complete this lecture, I feel I have completed my work. So I get discharged from this liability, or of course I enjoy this giving a lecture to you all. Likewise, contracting parties also have kind of a obligation to finish the work what they have to do. So that is where the concept of discharge plays a very, very vital role. Now, what are the important aspects of the formation of a construction contract? So I just gone through some of the construction contracts, the nature of construction contracts. So I know you are all experts in that, but at the same time, I thought I'll throw light on some of the vital areas which are creating certain judicial cases. One is you need to interpret the terms and conditions in a construction contract in the world of lawyers and engineers who are living the world of construction contract. Different interpretation will lead to ambiguity. Then multiple parties are involved, so this construction contracts becomes more important because you have a designer, you are an employer, you have a contractor, you have third-party experts who are coming into play, you enter into a contract with them. Then you have conceptual differences from that of a regular contract. So in a construction contract, you have multiple concepts which are there. That's why I always say this is a techno-legal topic, not only a legal topic, technological topic. Engineering language is embedded in a construction contract, which will obviously make it a multi-conceptual, terminological, legal document. And you need to identify whether a contract has been formed. In multiple cases, we have come across parties do not ascertain the importance of the formation of a contract in a construction contract. They assume that the formation has happened and they start working on, and then they understand that some important part of the formation of the contract is not there. There's a restraint, there's a constraint, and they're not able to go forward, leading to disputes where one party is favored and one party is not favored. So it is very vital for you to have identify whether a valid contract has been formed or not. Sometimes there are a lot of stages in entering into a construction contract, like negotiations. Parties negotiate with each other. They have expert negotiators also negotiate in the making of a contract. Offers are there, counter offers are made, tenders are there, advances, bank guarantees. These are all issues which crop up a construction contract, which in turn will make the ascertaining of a formation of a construction contract very, very difficult. So as I said, you may live in a world of belief that the contract is formed, but it may not have formed because of some kind of a complexity which is revolving around. So you all know that a construction contract is considerably different from that of a normal contract. You have drawings, you have specifications, the list of quantities, the risk allocation, how the risk is allocated, bifurcated, disseminated among the parties. And also every parties are having different performance. Responsibilities of parties have to be clearly demarcated, mentioned, and made. Both the parties should be made to understand what is their set of requirements. And also the most important aspect with regard to our area is dispute settlement and resolution clause has to be very clear in accordance with the present day situation. Why disputes come? I just made some good reading of a lot of articles, and I understood that some important reasons. There are many reasons for our lecture. I've just taken certain important reasons. One is anticipated execution. What is this anticipated execution? This is one of the most important reasons for disputes in construction contracts. So parties believe that the contract has been executed already, but actually it is not so, as I earlier told you. So with that belief, they start working, and the other party said, who told that I gave you the contract? I have not entered, we have not finalized on the contract. So they start working with the belief that the contract is already executed. So this is called anticipated execution. Second reason is complexity of documents. Documents along with the contract document are complex in nature, and certain parties do not understand the language, the manner in which the document has been put, and they misinterpret, and then they start having a totally wrong calculation about the contractual obligations what they had in a construction contract. Third thing is long duration of project. Someone told today's language is not what you understand tomorrow. So in construction contract, it's a time period. Sometimes it's a 1 year, it's a 2 year contract, and people completely forget about the responsibilities for which they enter into. Inconsistent interpretation. But multiple parties are there, as I told you. When multiple parties are there, they are interpreting in different ways. Your interpretation need not be my interpretation. I am a law academic. A law practitioner may have a slightly different interpretation. A judicial officer may have different interpretation. The judge in the court, High Court or Supreme Court have a different interpretation because of the nature of various jobs which they have involved in, which interpret, which have an influence on their interpretation. So bank guarantees are also a major issue. What banks are guaranteeing today for the parties, which also has to be understood in that financial legal language. Tender frauds are happening every day. Even today's newspaper, we read about a tender, talks about a tender fraud which is shaking the country, state government. So like that, delayed completion of projects and also variation and extension of time, which you in your popular language call it as EOT. Among all these criteria, the three very, very important criteria which I personally feel is delayed completion of project, variation in terms after entering into the contract, and EOT, that is extension of time which you are getting forth, will lead to dispute. Of course, some people will say these things need not lead to dispute when it is properly notified. I do agree that it need not lead to dispute. At the same time, there is a possibility that the time extension given or even the delay can all be important grounds of dispute as justified by the cases which are nowadays which are happening in courts in our country and also in arbitration which are getting resolved. So when you talk about delay and Indian Contract Act, so there are various sections. Once you enter into a terms of condition of a contract, then you cannot change it. Is not what we are to believe. Contract is highly flexible. You can make changes. Alteration, recession, novation are all part and parcel of contract. So you can make amendments to contract, no doubt. That is where the lawyers and the parties to the contract are acting as king and queen to among themselves, where they can make these changes. They can order these changes, no doubt. But at the same time, you have to be very careful when it is being made, when it is being made between among the parties. That plays a vital, very, very important role. Then you have when time is the essence of contract or not is a criteria. I cannot say in construction contract time is an essence and or it is not an essence. It again depends on the construction contract per se. If the terms and condition entered into a construction contract, looking into the factors, you have to analyze whether it is an essence or not. But nowadays, it is being framed in such a manner that time is not an essence because of the fact that there can be possible delay due to various criteria. So if it is an essence, according to section 55 of the Indian Contract Act, the option of the promisee, it is voidable. If the parties intend in a different way, then they will not make it voidable. Then they will make it go for compensation. Then when you read section 46 to 50 of Contract Act, you can mention that time need not be specified, reasonable time, proper place, and the time of performance can be assessed by the contracting law. Now, EOT clause, extension of time clause. It is very, very important to add that clause in the main contract so that parties get a possibility to go for extension of time whenever they need. So we have to assess the meritorious application of extension of time which has been applied by the parties to the other party so that whether it really merits or not. So relevancy of assessment plays a very vital role whenever an EOT notification has been made. There are a lot of contributing factors for the delay to be ascertained. Sometimes it can be an individual factor. Sometimes it can be a legislative issue. Sometimes it can be due to certain epidemic or pandemic situation like what we have now. And we have to ascertain what the factor is and accordingly take a call on EOT, the grant of EOT. And different types of contracts are there, as you all know. They assign different people and they ascertain whether it is needed or not. Okay, so variations in contract, novation, as I told you, it depends upon the parties. There can be because construction contract has so many things. It has a design, it has quantity, it has quality, it has scope of work, etc. So what you decided at the time of entering the contract may not be feasible at a later point of time. So you go for some kind of variation. But when you go for variation, whether both the parties accept, but in many cases there is a dispute because variation will lead to change of pricing. Party may accept variation, party may not accept change of pricing. That is where today we have a lot of models in construction contract, which you are familiar. I'm not going to talk about that for constraint of time. Like those models have auto change pricing policy, where the pricing keeps changing according to the schedule also keeps changing according to the variations which have been prescribed. If this is going to be the variation, this is the pricing. If this is the pricing, this is the schedule, time of schedule. Like that, they have an auto fixation for which is happening. Always formal writing is better. We talk about parole evidence rule in those days where there's a dispute between a written contract or a oral contract. But nowadays, courts jurisprudence have differed, and they are saying that formal writing is better, and a writing contract will always try to be a proper record for parties to resolve their dispute. So, valuation clause, if you include in the contract, that will also obviously reduce the disputes which the parties have entered into. So, when there is a dispute, the only thing is remedies. You can get the legal remedy. So, when you're talking about breach, we all know many types of breaches are there. Actual breach, where a breach has happened. Anticipatory breach, breach has not happened, but you are very sure that after some time the breach is going to happen. So you declare it to be an anticipatory breach. Sometimes it can be a minor breach, very, very minor, where you can get some minor compensation and finish it off. Sometimes it may be a material breach where you need to avoid the contract. So basically, section 73, 74 of Indian Contract Act, which even in the last webinar you went in detail. Section 56 also you discussed about doctrine of frustration, how the contract gets frustrated. When under these circumstances, when there is a breach, so you get certain remedies. So those remedies can either be through liquidated remedies or damages or unliquidated damages. And Indian Contract Act has provisions for both. At the same time, you have provisions where you can get some penalty also, and you have provisions where you don't avoid the contract, but at the same time you decide upon the sum which has been mentioned in the contract, and if it is reasonable, all the courts are giving orders to make payments for that. So proof of one important area which many people keep pondering is, when you are talking about the damages, liquidated damages, is it necessary that proof of loss is needed or not? There's an array of High Court and Supreme Court cases where finally the jurisprudence is well settled that if the language of the law is very clear, proof need not be exactly ascertained, but there should be some proof of loss. You cannot say that there was loss. You cannot say that there is loss, but I need not prove it. Burden of proof lies on the party who is making a claim that there is some proof of loss somewhere in terms of liquidated damages. So many people were getting relief through liquidated and unliquidated damages through the Indian Contract Act. Subsequently, they went for even specific performance under the Specific Relief Act 1963. And now I want to spend little time on Specific Relief Act because it was amended in the year 2008. So this amendment has also given certain very good directions to construction contract and also the people who are revolving in the dispute settlement under construction contract. First of all, what it has made, I'm just telling them 4 points alone, which you may know or you may not know. Firstly, making the specific performance of the contract as a mandatory remedy. So this is not an optional remedy. And earlier it was an optional remedy. Second one is doctrine of substituted performance was introduced. So you can, very, very vital for a construction contract. That means you can go for a substituted performance party, and whatever cost is happening for the substituted performance party, that can be recovered by the breaching party. So breaching party will have to spend for the substituted performance party was performed in lieu of the breaching party. So that has been introduced in this amendment, which is a very, very, very important aspect in construction contracts. And court has also been empowered to engage more technical experts to assist on specific issues related to the suit. the court, earlier it was a fashion of giving injunctions, and now the court is stopped from giving injunctions or restrained from giving injunctions, especially when it involves an infrastructure project. And because these injunctions will lead to too much of delay. Already we are living in a country where infrastructure projects are delayed. So even when the court is giving injunction, it is going to be too much of a delay. And so the Specific Relief Act amendment took care of that. And also special courts, state governments have been empowered to constitute special courts, especially for infrastructure projects, which are being notified and not taken in some of the states. And it is the most important thing is the time. It has to be resolved. The court suits has to be disposed within 12 months from the date of service of summons to the defendant. If the defendant gets a summons, within 12 months, the case has to be disposed, and maximum extension is in another 6 months when it is given in writing, for the reasons are recorded in writing. So basically, when you are a lawyer living the world of construction dispute settlement, so today some of the important clauses which are vital and very important is one, multi-tier dispute resolution clause. So you are all living in arbitration. So not only arbitration, prior to arbitration, pre-arbitration, pre-arb, that's what we call pre-arb clauses, where you have negotiation, you have mediation, you have different models, different schemes, different resolution mechanisms. So you are trying to create a multi-tier dispute resolution clause for the purpose of resolving a construction dispute. Second thing is involvement of an ADR mechanism. Third one is dispute, creating a DAB, what we call it as a dispute adjudication board, which is also considered as a pre-arbitration stage. I hope I'm not confusing you. Dispute adjudication board, which is also a pre-arbitration stage, but there are a lot of lacunae like delay, lack of expertise, lack of acceptance, and availability of appeal, in the sense that experts are not there. Sometimes you are there, but not throughout the country, right? So lack of acceptance in this kind of a multi-tier dispute resolution, and also like dispute arbitration boards. So these are the reason. And again, people can go on an appeal on this. That is the reason why this is not becoming proper. Then evidencing issues. Main problem with regard to evidence in construction contracts is the documents are voluminous. Of course, the more volume the document is, the more fees you can get from your client. That is one side of it. But the other side of it, it involves complexity in resolving the case. Then there's a need for interviewing the clients, interviewing the parties in a case. And that's a lot. That means what I mean is you need to go for a detailed interview. Then expert witnesses are required to resolve the disputes. And today we are living in a world of scarcity of expert witness. Parties appointed experts and court appointed experts, both of them are there. But there are a lot of problems in party experts because they are sometimes biased. And court appointed experts are not up to the purpose what is being solved. So that is where the document evidence also is always considered to be the best in India when you compare to expert witness and other things. Okay. So I like to say that enforceability issues is a major problem in various contracts, including construction contracts, but it can be resolved under various mechanisms. So as I told you, it is a techno-legal perspective which is always needed. It's not only the world of lawyers, but also more than that, it's the world of engineers where they try to involve, and you cannot say only engineering, law is also part of it. Updating of law and codes are needed. Like today, as we know, Specific Relief Act is so vital after its amendment. Likewise, trained judges who know the language of a construction contract, and if you have dedicated dispute resolving system, that also plays a vital role. And today, if you go through multiple judgments, not only given by courts and also arbitral awards, it all developed the construction contract jurisprudence, what I may call. So with this, I think I'll conclude, and I'm ready for any questions. Thank you.
Thank you, sir. It was a very valuable presentation. So we actually have some questions popped up in the Q&A box. So any other attendees who want to raise questions for this webinar in this particular topic can do so by opening the Q&A box down below and posting the question there. Sir, I'll be marking the question for answer live, and I'll be orally dictating the answer question. So if you would like to answer the question, you can answer so orally. The first question is by Mr. Engineer KD Arcot. If land for executing the work is not handed over to the contractor, even after 50% of the contract period, can the contract still be enforced by the owner?
If the land for executing the work is not handed over to the contractor,
even after 50% of the contract period, can the contract still be enforced by the owner?
yes, it can be enforced.
Okay, sir. Now we have another question. Sir, do you want to add more on that, sir?
No, it also depends on what was the reason for asking that question. On what background is that question being asked?
I'm sure Engineer Arcot could add on to that, sir. We'll move on to Mr. Satish Kumar's question. Under what circumstance does the arbitration clause in the contract becomes invalid due to flaw in a contract?
See, arbitration clause is legally valid. It is not restrained to legal proceeding, and it is an exception given in the Indian Contract Act itself. So arbitration clause is legally valid, no doubt. When it doesn't have validity is when a party is not totally consented to arbitration. If any factor forced him to enter into arbitration, which is affecting his consent, obviously then that arbitration, will not have legal validity. So many people, for example, enter into a contract agreeing arbitration as a dispute resolution without even having a knowledge that it was part of it. It can be because of illiteracy, or it can be because of some kind of a coercion or undue influence. Obviously, in such circumstances, arbitration will not be a legally valid dispute resolution because it was not agreed upon freely by the party.
Thank you, sir. The next question is by Mr. Karthik Shivakumar. How does the EOT and variation in a technical contract, in cases where the evaluation of the EOT or the variation clause is not mentioned, is interpreted under the law and awarded?
If EOT and variation clause is not mentioned in the principal contract, that is the main contract.
The method of evaluation is not mentioned in the contract.
Subsequently, if the evaluation has been accepted by the parties in a contract and they don't have any dispute, then they can go ahead with the evaluation which they intend as of now. If there is a difference of opinion, then only the problem leads to a dispute. But in the principal contract, you agree upon a system. This is where the valuation is. This is what, if the variation is there, you can go for this pricing, for this time schedule can be accepted. Then there won't be a dispute. And if disputes happen, the contract will always will override the disputes.
So the next question is by someone named Advin. How to solve the quality issue which can be found after completion and full payments made to the party?
This will come out of the purview of a contract, because parties have entered into a contract and the contract has been finalized subsequently at a later point of time. So both the promises have parties have fulfilled the promise, and you find some deficiency in the promise which they have later made. They have certain they can claim compensation for the loss what they have suffered. See, one is contract law, what we are talking. Another one is we are living in a world of consumerism. Today, consumer protection acts have come across, and you are having a lot of forum to resolve your disputes under the concept, under various jurisdictions. Yes, Vedant.
We have few more questions, sir. By Mr. Vir Pratap Arora. Whether employer can raise counterclaim towards the liquidated damages even if it was not invoked at the appropriate time during the execution of works.
Can you repeat the question? Sorry.
The employer can raise counterclaim towards the liquidated damages, even if it was not invoked at the appropriate time during the execution of the works.
Sorry, I didn't understand it.
I guess it is not phrased correctly, so it's okay. We'll shift to another question by Mr. Sudhindra Krishnachar. If the contract is of supplies and services, can we introduce a clause that payments to subcontractors of supplies be made directly by the owner in case the contractor does not make any payments to the subcontractors?
Yeah, it is possible. If parties agree to it, then there is no issue on that.
Thank you, sir. Maybe one last question, sir. We have another minute left. A question by Girish HR. In a subcontract, is there a concept called pay when paid valid?
Yeah, you can have that clause.
Sure. Thank you, sir.
It's only a mode and time of payment, and that clause you can add on, no problem.
So we actually have quite a few number of questions, sir, but due to the brevity of time, I think we can close the Q&A sessions for now. And for the attendees who have not gotten their questions answered, you can please share your questions to kfcri.adr@gmail.com or IITArbHQ@gmail.com. We'll try to forward it to the speaker or the institutions and get it answered as soon as possible. Thank you, Professor Ranjit, for joining with us. I would like to hand it over to Dr. Colonel P. Nalathambi.
Good evening. Before that, I want President to say something, followed by our engineer O.P. Goyal sir, the past President, and Seshadri sir. And then I'll go for that vote of thanks. Mr. President.
Yeah, thank you. I must congratulate Professor Ranjit for really covering very comprehensively the topic. It was a good revision for me, and it must have been the same for many of us. The number of questions which have arisen shows the amount of relevance of this topic. Probably we need more of this to our people. There are some very basic questions involved here, and some very basic questions have been asked, and therefore the it was certainly very relevant. So I thank you very much, and thank you the organizers. And I request Shri O.P. Goyal also to say a few words before we close.
Unmute, sir. Yes, to unmute it.
गोयल साहब आप अनम्यूट कर लीजिए, वो नीचे जहाँ म्यूट बटन है.
Thank you, President, and the other institute's organizer, Mr. Is not there, our old friend. A very good lecture, very comprehensive, as Mr. Agarwal, President, has said. In my opinion, it could be further, the time was short to cover more practical aspects. It may be useful, because IITArb is holding a lot of webinars. We must hold on specific subjects. Dispute resolution should be taken separately, and contract clauses also. As the first one I attended was on frustration and similar issues. That was more focused. This is a refresher course on the whole Indian Contract Act, and very, very useful, as has been said. I must congratulate the organizers and the speaker, very well delivered. But it needs, time was short, and it needs a focused attention for specific subjects, because the answers to questions have also not come. We should allow not more than 45 minutes or even less to the speaker, and allow 15 to 20 minutes minimum for questions and answers. Thank you very much. I am very happy that IITArb headquarters are organizing a webinar almost every week. Please keep it up, President Saab and Seshadri Saab and Colonel Saab over there. Thank you.
Thank you, sir. Past President Seshadri, sir, please.
Thank you, Mr. Nalathambi. I am glad that Professor Ranjit has done the topic, which is widely to be covered in a very, very short time of 40 minutes. It requires more time. Similarly, the questions also, the large number of questions were there, could not be cleared in a shorter duration. And I am very happy to see Mr. Goyalji and Agarwalji in the screen. And we continue to conduct more meetings through webinar as requested by our president. So I take this opportunity to thank the IITArb and KFCRI for the excellent start we have made during the lockdown period. Thank you very much.
Invergent, sir, can you sum it up? Unmute, sir.
Yeah. Good evening. Good evening. I am really happy to see all my senior friends along with our president. I could remember the days when I sat with engineer Goyal Saab in a DRB. It was a big DRB where we did it in Niti Bagh, Delhi. The same energy I could see with Goyal Saab. I am happy. Thanks for joining us today, sir. Then I have to obviously thank Engineer Seshadri, wherein the relationship of training, providing the training on behalf of IITArb, not only recently, a long period. I could remember the days when we started in the Neyveli Lignite Corporation and the Kochi Port Trust. All these as a nostalgic feeling has made a reality by our present president and the team, wherein a webinar is reaching all the platform, particularly the members of IITArb, which was literally not possible some years back. Now it is possible to reach all the members. And this initiative, what IITArb has taken with the technical support of KFCRI, would go to a longer stretch to the maximum reach. And ultimately, we will be an effective arbitration institution for technical arbitrators. Colonel Nalathambi, sir, now we can just pursue the vote of thanks.
Thank you so much, sir. I, Dr. Colonel Nalathambi, Joint Secretary General of IITArb and the coordinator of this webinar, I take opportunity to deliver word of thanks on today's webinar on contract enforceability issues by Professor Dr. Ranjit Ommen Abraham, Tamil Nadu Dr. Ambedkar Law University, Chennai. I thank Professor Ranjit for accepting our request and giving a webinar lecture today. With his vast experience in construction law, he had delivered an informative lecture today. I thank the President, IITArb, Engineer K.N. Agarwal, past Presidents, Engineer O.P. Goyal, Engineer Seshadri, and Vice President, Headquarter Engineer Sivaprakasam, Secretary General Engineer Sivaraman for initiating the move to hold webinar lectures in association with KFCRI and his team. I thank Advocate Inbavijayan, KFCRI sir, for organizing this webinar. He had taken initiative, shown willingness and interest to hold his second webinar. I thank KFCRI team members, Advocate Shahrukh Kumar for organizing this webinar and communicating to all IITArb members to make the event successful. I thank all our IITArb members for sparing their valuable time and attending this meeting to make it successful. Next webinar is planned on accepted matter in construction contracts and jurisdiction of arbitrators by Shri Ganesh Chandra Kavi, former Chief Engineer CPWD and arbitrator, is scheduled on 27th June 2020, that is Saturday at 16:30 hours. The link will be sent later. Once again, I thank all of them for attending it. Thank you so much, sir.
Thank you, sir.